This is Crime in Court, and my name is Heather, and I'm here with another Delphi update. This was actually another motion filed by the state yesterday, or no, I'm sorry, not yesterday, the 29th. So this is the response that the state has to the last motion, which was actually by the previous attorneys, Allen's previous attorneys, Scremin and Libredo. They put in a motion to have Richard Allen transferred to a local a, a jail versus, a county jail versus a state prison. So in that motion, they talked about the way that he was being misused and mistreated there, and difficult issues to it was difficult to visit them. It takes a long time to get in and out, and yada yada yada. So I didn't want to go over the whole thing, but that's kind of the abbreviated version of what their document was. They wanted him moved to a county jail much closer to where their offices were, and to where they would be able to have sit down conversations with their clients, because um, their conversations were not very well handled, and we'll kind of get into that. And this is actually the motion from the state in response to the horrible conditions Richard Allen is in. However, they kind of are treating it as if they are referring to Bradley and Rosie, the current attorneys, even though the other attorneys submitted this. So it's very confusing, and it's also the fact that just he kind of incriminates himself in this whole document, and it's kind of mind-boggling. So let's begin. All right, so the state's response to the defense motion for transfer. Now comes the state of Indiana by prosecuting attorney Nicholas C. McLeland, and respectfully informs the court that the state has no preference of where the defendant is held. We have no preference before pretrial, okay? But the state believes that it is in the best interest of the case as an officer of the court to inform the court of the exaggerations and inaccuracies outlined in the defense's third motion to transfer. So this is now the third motion. The one that Libredo and Scremin put forward was the third motion, and they're acting as if, or in Nick's response, it's as if he's stating that Bradley and Rosie almost are saying these things, or I don't know. It's very confusing. But anyway, so here. The state would ask the court to consider the following. One, that charges were filed against the defendant, Richard Allen, on October 28th, 2022 for 2 counts of unaliving in violation of Indiana Code, whatever. Number 2, that the Carroll County Sheriff's Department requested that the defendant be transferred to the Indiana Department of Correction for safekeeping, and said request was granted. So they're saying because you did ask for a transfer, we gave it to you. Even though it was done in secret, nobody knew where he was going, and there was never really a justification as to why he was going there. We were never told. So it was like a secret moving of him. All right, so that defendant was transferred to a Westville Correctional Facility on November 3rd, 2022. Oh, that was not the secret one. He was in the county jail? County Sheriff's, he was in county here. And they said he needed safekeeping, transferred to the Indiana Department of Correction for safekeeping. So he was in county here after he was arrested, and then taken to Westville Correctional Facility, which is a state prison. And he is not a convicted felon. He should not be in a prison. He should be in a county jail, like most people who are awaiting their trial that are not lucky enough to get out on bail. So, number 3, that the defendant was transferred to Westville facility on November 3rd, 2022. Number 4, that the defense filed an emergency motion to modify the safekeeping order on April 5th, 2023, which was denied. All right, so I don't know why that was denied, but it'd be nice if they told us. Number 5, that the defense then filed a motion to reconsider and request for due process hearing on May 3rd, 2023. Number 6, that the hearing was held after which the court denied the defense's motion to modify the safekeeping order, stating that the allegations advanced by the defense were not supported by the evidence presented. The court added that the defendant was being treated more favorably than other inmates housed at Westville Correctional Facility. I don't know how that's possible when you hear the things that were alleged in those documents by his attorneys. Both Scrummon and Libretto and Rosie and Baldwin have all stated in some form or another that Alan is not being treated fairly. He's segregated from the rest of the population. He's isolated. He has no privacy. Every move he makes, he is, even when he's trying to talk to his attorneys, those conversations are overheard by guards, recorded. And so we'll get into it. All right. So number 6, that the hearing was held. Oh, we just read that. Sorry. Number 7, the court made a finding that it is reasonable and necessary to house the defendant at Westville Correctional Facility to ensure the defendant's safety to prevent serious bodily injury to himself. So they wanted him moved, but the judge said, no, this is the safest place for him, even though they were coming to her because he was not safe. Number 8, the defense then filed a verified motion for immediate transfer of custody, alleging additional mistreatment of the defendant at Westville Correctional Facility. Number 9, that once again the court stated the defense's assertions were factually inaccurate and were refuted by the evidence that the state provided, therefore denying the motion. And that just seems to be the way that most of his motions have been going, that they're getting denied by Judge Gull. And often without even a hearing or due process, which is not giving him his fair right for a trial, his constitutional rights. She's trampling all over them. And I don't care that I just said that. Judge Gull, is trampling all over Richard Allen's rights. All right, so number 10, that the Department of Corrections then transferred the defendant from Westville Correctional Facility to Wabash Valley Correctional Facility. This was the secret transfer, I believe. Yes, that was Wabash is where he's at now. So, which is even further away, and it was like a 10-hour day. His second attorney said. His second state-appointed attorneys, Scrummon and Libretto, they even said, it was like a 10-hour day to go visit him. The drive alone was over 3 hours, something, and I don't know. So whoever made the reason, or whoever decided to move him to Wabash, we still don't know. It was just done in secret. I mean, we might have something on it. They might have told us, we really weren't told that it was being done or given any explanation as to why it was done or why this Wabash Valley Correctional Facility, and it was done in the middle of the night. So what does that tell you? Number 11, the new counsel of the defendant has now filed a third motion to transfer. So that's Scrummon and Libretto now. Number 12, that the state has no opinion where the defendant is housed during the pendency of the case as long as he is kept safe. No opinion. But we wrote this several-page document to let you know that he should stay put. But we have no opinion. None whatsoever. All right, so the state believes that it is imperative for the court to have accurate information in order to make its decision, which is lacking from the defense's motion to transfer. So let me tell you how it really is, Judge. Number 13, that counsel for the defendant reference the emergency motion to modify safekeeping order filed by prior counsel and how they find the allegations in that motion meritorious. Number 14, that the motion has already been litigated at length and the court found the allegations outlined in the motion were without merit. Number 15, counsel references a letter written by an inmate, Robert Baston, at Westville stating that the defendant is being mistreated as a fact to be taken as true. Remember, that was in the motion provided by Andrew Baldwin and, Scrimmon and Libredo, that there was mistreatment on their end at the Westville Correctional Facility. He spoke about how he had seen Richard Allen being beaten and, tased and things like that. So the state has documented Robert Baston's history with the court in prior hearings and filings with the court. The allegations by Robert Baston are not reliable evidence provided as sworn testimony, nor has he been subjected to cross-examination. Okay, fair. Bring him in, examine him, ask him, do the cross-examination. But he's probably going to tell you Richard Allen's being abused because that's what's happening there. He's being mistreated, misused, and used as a punching bag, emotionally, verbally, physically. That's what's going on there. And the justice system just wants to seem to leave him where he is. I don't know. Number 16, that counsel for the defendant reasserts that the defendant is being mistreated by guards at Westville who practice Odinism. There's that word again. Even Scrimmon and Libredo brought up the Odinist theory, the Odinist tie, because of the guard who had an Odinist tattoo on his face after the patches were removed, and Scrimmon and Libredo noticed it. They put it in their motion. So it's not just Andrew Baldwin, and it's not Rosie thinking this only or coming up with some dastardly plan to get Richard Allen out of prison or get him out of the indictment. It's because there really could be this tie to Odinism, and the correctional officers at both Westville and Wabash correctional facilities are in it. I think, and this is just my opinion, this is my speculation, my conspiracy theorist mind going. I think it's so much bigger than we know. I think Odinists have infiltrated the justice system, law enforcement. They're everywhere. And we just don't know it or didn't know it until this motion became public. And they've done a good job of hiding themselves, I guess, as just some kind of group that gets together and talks about the weather. I don't know. I never heard of it. I'm in the Chicago area, suburbs only. I never heard of this Odinist thing until this motion. So anyways, it's weird, but it's possible. Anything's possible. If those who close their minds to any kind of theory, I feel sorry for them for not being able to think about it and criticize it in depth and fully, and make up their own mind and their own decisions. Some people hear one thing and it resonates with them, and that's all they gravitate to, and I think that's the wrong way to be. I think we need to see it from both sides. That's why I really like looking at these cases from the defendant side, because no one's doing that. Mainstream media is making these people monsters before they're even convicted, and I think that they are owed due process and a voice. And now we've got all these gag orders with Delphi and Idaho 4, and then it makes conspiracy theorists just, I mean, the theories run rampant because nobody has any explanations. So you just come up with them on your own. Well, not you, but you know, the collective you. So it's crazy to me. I think it there's so much more, and I think it's very insidious whatever this Odinist tie is with law enforcement, the legal system. They're like within society hiding in plain sight, and it's really a scary thing to think about. Anyways, all right, so number 17. Again, this issue has already been addressed in a previous motion and was found to not have merit and the motion was denied because Judge Gold denied every motion from the defense team pretty much. Number 18. That defense then make the allegation that the defendant was denied recreational time and showers at Westville Correctional Facility. Number 19, that the defendant has never been denied recreational time or showers at Westville Correctional Facility. Remember in the last motion, Scrumman and Libredo said that Richard Allen was even afraid to ask the security guards or the correctional officers to take him to the shower because it was inconveniencing them. Sorry to inconvenience you on your job doing the thing that you're supposed to be doing, but can you take me to the shower so I don't have to sit here unbathed for days? Which is unfortunately what he said had happened. He said he had been at Wabash for 2 weeks or so, and he only had like one or two showers. So there's definitely some way that people are treating him, and you can laugh about it, Nick McLeland, but it's multiple people now have seen it. So I don't know where this whole motion's coming from, where these corrections to the record are coming from. All right, so number 19, that the defendant was ever denied recreational time or showers. Number 20, that when the defendant was moved from Westville Correctional Facility to Wabash Valley Correctional Facility, he made statements about committing self-unaliving. As a precaution, he was examined by mental health professionals, and they determined that he should not be given recreational time until they can be sure that he would not hurt himself. So what does recreational time and hurting himself have anything to do with one another? Are there not guards when they're out in recreation, like outside? For the recreational time? Are guards not guarding them? So why would he need to be on like super surveillance? I don't know. It makes no sense that he wouldn't be able to go out and have recreational time, even if he was on this self-unaliving watch. So once he was off this watch, his recreational time resumed. I still don't think that that's a valid reason. It's not a valid reason, Nick. All right, number 21. That counsel next complained that the check-in process at Wabash Valley Correctional Facility is too burdensome and time-consuming. So here's what we did. Because we didn't believe you about how time-consuming it was to go check in at the facility. We don't believe, we think you're lying, you attorneys who have been credible attorneys for how many ever years you've been practicing. We think you're lying, and we went and we checked. And number 22, the state was able to review video footage from counsel's visit with the defendant at Wabash Valley Correctional Facility. Counsel for the defendant arrived at the facility at 12:35 p.m. and were processed to visit with their client by 12:58 p.m. That the wait time was extended on this date due to power outage in the facility, but in total lasted, that should have probably have been another point, right? 22, 23. Anyways, in total lasted 23 minutes, not the nearly 1 hour alleged in pleadings. Okay, so they're saying it didn't take you an hour. It was only 23 minutes. That's not long. Whatever, get out of here. You still shouldn't have moved him without his counsel or without his permission. He didn't want to go. This case makes me mad. What do you guys think about this case? All right, number 23. That the facility typically does not allow face-to-face visits, but did accommodate counsel and set up the defendant in a special room seated behind a door that was see-through that had slots where documents, papers, or whatever could be passed back and forth. So, speaking of that, where is it? Oh, here. So this is the door to the cell. Ah, I didn't mean to move my other thing. Stop moving. So the picture in front of you is the door to the cell where Alan, I can't make it much bigger. So there's a blue chair back here, and this is apparently the slot where his attorneys could speak to him from. However, if you remember from their motion, they had a table that was at least 6 feet away from this door where Alan was seated, and Alan was seated a few feet back from the door as well. So they were quite a few feet back away from each other. They had to scream or yell, like they had to raise their voices to speak to one another, and there were guards nearby and surveillance. But that's what we're about to get into next. So, do you guys want to keep this up? Okay, come here. These things don't want to move smoothly. All right, we'll put that on the side here. Not to cover me, but right there. So that's his cell, or at least that was where they're housing him for for attorney-client meetings, conversations, where they have to sit 12 feet apart, and that's the door in between them, and they can only use this little slot to see things or to pass things along. So number 23, the facility typically does not allow face-to-face visits, but did accommodate counsel and set up the defendant in a special room seated behind a door that was see-through that had the slots. That's what the slots there. Number 24, that the surveillance camera was present in the room that records movement only and no audio recording. So they're saying their conversations with Scrumman and Laredo and Richard Allen were under video surveillance, which shouldn't have happened, but they're saying that there was no audio. Even though there was no audio, I still don't believe that they should have recorded, because you can make inferences. You can try to read lips. I don't know. You still shouldn't have video of that. The prosecution should not have video of that. The only thing that was recorded from the visit is when counsel entered the room and when they left. That, to the state's knowledge, any jail that attorneys visit to meet with their clients is video recorded or monitored in some fashion. That is for the protection of the attorney and the defendant. So they're saying you should just expect to be videotaped when you go see your client. No. Number 25, that neither attorney brought a computer with them to provide the defendant with review of video or audio discovery, even after DOC made accommodations for them to do so. You don't know that. Maybe they decided not to show it because they knew that they were being watched and listened to. All right, so number 26. The defense were told by legal counsel for the DOC that if they needed anything additional to meet with their client, to just ask and accommodations would be made for them. Well, how about a room with privacy where you guards aren't listening to us and we're not being videotaped, and I can sit next to my client or across the table from my client. That's what I want. But they didn't give him that. So to each 27 to each that each request for counsel for the defendant have been made of Wabash Valley Correctional Facility has been granted. They're missing a word there. 28. All this is to say that the allegations that the defense outlined are exaggerated and misleading. I think he's misleading us. But what do you guys think? All right, they are able to meet with the defendant, show him discovery in whatever format, and meet with him in a very effective way. This seems to be more of a motion about convenience for them instead of zealous representation of the defendant. Baloney, Nick McLeland. That is baloney. It's not about convenience, although yes, I'm sure that's part of it, but you have to be able to go see your client, and it takes away from your other clients if you're holed up in a prison for 10 hours or in the car driving to a prison all day. But they don't care. The state doesn't care. All right, 29. But they don't have an opinion on it, guys. No opinion, no preference, but here's all the reasons that he should stay where he's at. Number 29, that the state pulled the records from Wabash Valley Correctional Facility, spoke to legal counsel of the Department of Corrections, and reviewed the video surveillance from Wabash Valley Correctional Facility, and the allegations put forward by the defense are inaccurate. 30, that the defense had a tablet in his cell that he can communicate with his counsel at any time, and has had his tablet since he's been there. So that was one of the things too, I believe, in the motion, that he didn't have access to a tablet. But other inmates do. 31, that in addition, okay, but I just want to say, like, it's easy for Nick, who's not even there all day, to say, oh yeah, he's got his tablet all day. How do you know? You're not there. How do you know that? This infuriates me. All right, so number 31, that in addition, since the motion has been filed by the defense, the DOC has set up video conferencing so that the defendant can now meet with his counsel via video. Well, isn't that nice of you? You should have done that before, when you transferred him hours away. Number 32, that the defendant has commissary in his cell where other inmates do not. Okay. We prove it. We don't know that. You're telling us something, but it doesn't make it true. 33, that the defendant is being treated far better than any other inmate in the DOC. Can you believe that? We're treating him so good. That's why he lost all that weight and looked terrified at the last few hearings. That's why, because we're treating him so good. I'm sorry. It's laughable because if you don't laugh, you cry. If you can't have fun, I don't know, then life's just too depressing sometimes. Number 34, that the state also spoke to Sheriff Dan Mahor, or Mahor, I don't know, Mahor, Mar, what do you guys think? How would you pronounce that? I have no idea. Sheriff Dan from Adams County, and he is not willing to accept the defendant at his facility. He does not have sufficient space or accommodations to house the defendant. The Adams County Jail also does not have the mental health professionals available to address the defendant's mental health needs. Well, I also say that maybe he won't need such dire mental health needs if he's in a facility like a county jail where he can see his attorneys anytime. He can talk to his wife, or have communications on his tablet, and have normal freedoms that normal prisoners get. He's not even getting the same freedoms, but we're treating him far better. Don't you worry. And I wouldn't take McLeland's word on any of these facilities not wanting to take Alan in, because I don't think they're trying to move him very hard. So, Number 35, that the state spoke to Sheriff Troy Hirschberger from Allen County, and he is willing to accept the defendant in his facility, but only at the expense of Carroll County. However, the Allen County Jail is currently overcrowded, and Sheriff Hirschberger would have to make special accommodations to house the defendant. So they don't have a place for him, but we'll take him on your dime. I don't know. In addition, the Allen County Jail does not have face-to-face visits. All visits are done via video, including attorney visits. So that's something to keep in mind. Number 36, that the defense continues to make unfounded accusations supported by insufficient proof. Show us what insufficient proof, because you just proved to us that you house Allen in that jail cell that's on the screen right now, this one right here. So you gave us confirmation that that's how they are doing their meetings. That's how they're accommodating their meetings, and that's doesn't seem humane. That doesn't seem right to me. Seems humiliating. Think about yourself. If you were in Richard Allen's shoes, guilty or not, whatever the crime is, it doesn't matter. If you were in prison for something and you were being isolated and treated differently than everybody else, and when your attorneys, the two people that you thought were there to save you, or the only two people that you have as your lifeline, you can't even talk to them privately. That's the room that they make you sit in, this room up here, and have a you're supposed to have a conversation when you're 12 feet apart. I don't get it. Anyways, sorry, I forgot where it was. 36. Oh, they're making up unfounded accusations and have insufficient proof. Where? Show us where. What accusations are unfounded. Number 37, that the Carroll County Sheriff's Department does not have the manpower to transport the defendant or the room to house the defendant in a manner that ensures his safety. That the Carroll County Jail does not have mental health counselors or counseling to address his self-unaliving concerns that have been ongoing. Well, maybe they wouldn't be if he was being treated like a human being and not an animal. Worse than an animal. 39. That once again, for the third time, the colorful, dramatic language used by the defense is an attempt to curry public favor for their client and try this matter in the public eye instead of in the courtroom. So they're trying to say that the attorneys, and now this is a second set of attorneys who are trying to do this. They're trying to skew the story so that the public views Richard Allen as a victim and feels sorry for him versus, the truth that the state has on him, that he's the actual unaliver of Libby and Abby, even though we have no confirmation or ties to the girls that we know of. I don't know. Number 39, that once again, for the third time, the colorful, dramatic language used by the defense is an attempt to curry public favor. I just read that, damn it. I do that all the time. I don't remember what I just read. But yes, so the third time is apparent. Apparently it bothers. It really bothers Nick McLeland that they keep coming out with these motions and stating Odinism and talking about these things that they really don't want out in the public. And once it's talked about, they're like, oh, this is just colorful and dramatic language. And you're just using these motions for getting the public in your favor, which they're public motions. The state has been doing it since day one. When they announced that this happened, they've been painting a picture of who the unaliver is. And then they put a face to that person, whether that's the right person or not. We know that there was some political stuff happening in the background with perhaps a certain Tony Liggett. Where is he? Let's put him on the screen. Liggett was there's Liggett. So we talked about him in my last episode or part of the reading of the Delphi Frank's memorandum document. So we're doing it in parts because it's a 136 page document, so we're cutting it into parts. So if you're interested in reading that Frank's motion, which goes deep diving into Odinism and all that and who's involved, and it names other persons that might be involved, there's a playlist for that and for Delphi, and you'll see the different parts for reading that document. And we're still going through it, so we're not complete yet. All right, so 38, that the county jail does not have mental health counselors. 39, that the colorful language. 40, that again, the state has no opinion. We have no preference, no opinion on where the defendant should be housed awaiting trial. But the state does take offense to the defense once again filing a motion with this court that is full of inaccuracies and allegations not supported by sufficient evidence in order to influence this court to move the defendant. Which I think is baloney, because they had plenty of sufficient evidence. So this is basically just an attempt for Nick McLeland to try to discredit Andy. Well, now it's Andy and Rozzy, but before, he's trying to discredit them, both teams. But he's saying they're all liars. Both sets of attorneys are all lying. Anyways, the state has no objection to the defendant being moved to a facility within the Department of Corrections, but the court has already addressed that issue in a previous order. Number 4, that the defense is consuming the limited resources of this office and this court with repetitive motions that lack any factual basis. How dare you come to us with your accusations that are likely true? How dare you? It's just wasting time and our resources. Wherefore now the state of Indiana, by prosecuting attorney Nicholas C. McLeland, and files their response to the defendant's third motion to transfer, and would ask the court to consider the same when making its decision and for all other just and proper relief. So that is Nick's, oh yeah, here's another picture of that. Both of those pictures. So one's on one side and one's on the other, and that's their door. Okay, so this is the outside of the door, then it appears. The other one's the inside of the door. That's Rick's vantage point. Let's look. So Rick would be looking out this way because the lock was on the other side. So that's the attorney's chair. One single blue chair. You can see several feet away from the door. And then Rick has to also sit a few feet away from the door. It looks like he's a little closer because of the cell being small. But he's also not right up against the door. So there's quite a few feet in between. And you can see this little slot. How you're supposed to have a conversation with someone. This makes me very sad that people are treated this way. So that is that for this motion. What do you guys think? Let me know. We know the defense is probably going to come back with a response. So I would be curious to see. And but before anything happens with Rick being moved or anything like that, Brand attorneys Baldwin and Rosie have to go through with the disqualifying motion of Judge Gull. So they've put in a motion to disqualify her, and they're going to have a hearing for that before anything happens. However, what's really effed up about it is that Judge Gull gets to be the presiding judge over the hearing of whether she should be removed from this case or not, which is just irritating. And I don't even know how, like, the Supreme Court knew that. The Supreme Court knew that that was what was going to happen if they didn't take it away from her when they just had this ruling of reinstating Baldwin and Rosie. So why didn't they think? Maybe they figured that they'll have to just figure it out themselves and it's not our place, because I think, they're cautious to overstep when they shouldn't. But what do you guys think about this case, about this particular cell setup that they have for Baldwin, for the attorneys and for Richard Allen? My brain's not working today for some reason. Sorry, guys. I don't know. I just think it's all too many complaints, too many consistencies between the two different sets of lawyers. In my opinion, they're both stating Odinist ties. They're both stating mistreatment of the client and the inability to give them fair and effective counsel, because every word that they were saying was being listened to. So, all right, I will let you guys go. I could talk about this forever. I'd love to hear your guys' opinions down below. Please let me know what you think. Don't forget to like, subscribe, and hit that share button. And, if somebody else is interested in this case, don't forget to share. And I hope to see you next time. Take care. Bye.